Hi, this is Brian Hyde, and just wanted to give you a quick update. It's the day before Thanksgiving, so there was only a partial day of court today. But from what I'm hearing from our friend Doug Knowles, who was in the courtroom, it was a pretty active day. And as you might expect, based on the lesson, the incredible lesson that Ryan Bundy was able to teach the jurors and even some of the attorneys, particularly one of them whom he was cross-examining at the time, and others in that courtroom, the prosecution today came back pretty hard. They obviously spent the night figuring out how can we undo the damage to our case that is being done. And I think the way that they put this is they portrayed it as this is a collateral attack, or this is the prosecution is being attacked as if somehow we're the bad guys for what we're doing in prosecuting the Bundys. And so they obviously want to limit what can reach the jury's ears. They don't want a number of questions being asked about, for instance, the 15-page threat assessment, which was just made available to the defense. And the jurors know that the assessment exists. They don't really know what's in it, but the government is very insistent. There's really nothing there. There's nothing there, which you have to ask. If that's the case, then why would you even hesitate to release it? Why wasn't it released a long time ago? Why would you object to the jurors seeing it now, if in fact there's nothing there and it poses no threat to their case? Seems like, in this case, maybe their protesting speaks volumes about they fear the jurors understanding this. They're concerned, and you knew this was going to happen based on the way that the prosecution and even the judge was behaving in the previous two trials in Vegas. They're learning from their mistakes. And I know, what's the old saying? Never interrupt your opponent when he or she's making a mistake. Well, they're learning from their mistakes. And one of the reasons why, in particular, the attorney for the government, Sheese, yesterday did not object, even as the Constitution was brought, even as Ryan was doing this marvelous job, and Brett Whipple was doing a fantastic job too, of schooling those people in the courtroom about some of the underlying principles that are at stake here. The prosecutors were careful not to jump up and to object because, in their words, they didn't want to be seen. This is what they were telling the judge out of the earshot of the jury, is we don't want to be seen as, adversarial or the aggressors here. We don't want to be the bad guys. They don't want to be seen as attacking constitutional things. And yet, what are they doing? This is the conversation taking place out of the jury's sight. But when the jury's there, they want to play like, oh no, hey, we're just here about, this is all about justice and law and order. I don't know, having sat in that courtroom and seen the cockiness and that self-assuredness that, oh yeah, we got this. It don't get much better than what we bring to this game. I think that they're very concerned about losing, and I think winning has taken precedent over the pursuit of justice, and actually did a long time ago. It's become about winning and possibly about saving face following the previous two trials. They actually mentioned jury nullification, not in front of the jury, of course, but they're worried that the possibility is that the jury is going to see through the case that the government is throwing or is bringing forward, and they're going to